SJC-11493, Ronald T. Garney v. Massachusetts Teachers Retirement System.
Yes, Counsel. Good morning.
Good morning, Mr. Chief Justice, Associate Justices. My name is Robert Fabino. I represent the Appellant Teachers Retirement System. Your Honors, as you may recall, just last week you issued a decision in Somerville Retirement Board versus Bonomo, a Middlesex register of probate. And as you may recall, that issue also dealt with the application of General Laws, Chapter 32, Section 15.4. And what is noteworthy about that particular decision in the context of the case before you today is that the focus of that decision didn't deal specifically with the direct link analysis, the factual direct link analysis discussed in Gaffney, but instead it dealt with this higher standard enunciated in Bulger, John Bulger, the court clerk, who was convicted of perjuring himself in federal court. The Bonomo analysis was similar to Bulger. It was also similar to Durkin, which was an appeals court case involving a Boston policeman who shot his fellow coworker off duty.
But with a police revolver.
With a police revolver, yes, Your Honor, that's correct. So Durkin's interesting because on the one hand, you have that direct link, that factual direct link analysis discussed in Bulger. You could end the analysis there. It exists. But at the same time, the appeals court went on to discuss this higher standard of a police officer.
Yeah, but I don't know how far it goes. I mean, even with a police officer, would a police officer lose his retirement pension because, for example, he had an incident of domestic violence with a family member involving no use of police-issued weapons, totally domestic, totally within the home? Would that be, and even though, of course, the purpose of a police officer is to protect everybody from harm, including presumably members of his family, but would that really go that far? I guess the question is, you know, the line drawing. There's a difference, too, between public officials, such as Mr. Bonomo and Mr. Bulger, and someone who's yes, the job as a teacher, and that's a public job, but it's not of the same nature. It's not an office. It's not an elected position. It's not one of that. It's not quite the same thing. And I guess I'm just wondering where your position goes. I mean, is it for a teacher? Is it any sex crime involving children, or any sex crime, even if done like out of state with a relative's child, a non-contact offense? Is it the fact that it's an offense that somebody could be terminated for doesn't mean that that's the standard for the retirement?
Correct, Your Honor, and we don't submit that today. The standard for termination from employment and loss of pension benefits is arguably different, but what we'd submit to answer your specific question, had the offense against a child occurred out of state, say in Nebraska, we still would submit to you that 15.4 would apply because it involves the laws applicable to his position in the sense that, and we cite this in our brief, Chapter 71, Section 30 lays out the fact that a teacher is charged with the care and protection of children. DESE has a regulation dealing with a teacher's proper conduct with the internet.
Yeah.
So in those particular instances, we feel as though those laws, those violations, no matter where they occur, in the school building, in the privacy of his home, out of state, he would involve in this case, Mr. Garney would involve, his criminal offense would involve the violations of the laws applicable to his position in the sense that he violated Chapter 71, the DESE's regulations, as well as the standards laid out in the case law in Dupre and Perryman, which we highlight in our briefs, and say that teachers have heightened responsibilities.
Sorry, I didn't mean to interrupt you. But the Lambert case, the Superior Court case,
Yes.
I understand, but the Teachers Retirement Board is the party there.
Yes, that's
You
correct.
did not appeal that case, is
That's
that
correct.
So what's the difference between these two cases?
Lambert and Garney, Your Honor. Lambert, we feel as though was wrongly decided. The court did not get into this standard discussed in Bonomo, the standard discussed in Bolger, the standard discussed in Durkin in terms of go beyond.
So the lack, I'm not saying you have to appeal everything, but it's not because the reason you didn't appeal is not because, or the board didn't appeal, is not some factual difference in the case. It just happened that that one didn't. Is that fair?
No, Your Honor, and I see your point. So in Lambert, Mr. Lambert only allegedly viewed 9 images of child pornography.
But he contacted a student in the school, you know, he used, as I recall, or he attempted to use the school computers. I mean, there was some facts on the facts that were actually more connected to the school than in this case.
Judge Kottmeyer actually addressed that particular issue in terms of Mr. Lambert attempted to access child pornography at school, but a firewall prevented him from doing that. And Judge Kottmeyer said that was a fortuitous event. Had he been successful, then forfeiture would have applied. But I submit to you, that's one of the problems with that analysis. Had Mr. Lambert accessed child pornography at school or at home, in the privacy of his home like Mr. Garney did, we'd submit to you that the same result should apply. He violated the duty of care to protect children.
So if getting back to Justice Lank's question, if the teacher is found guilty of assault and battery because he uses excessive discipline as to his own child at home, he can forfeit his pension.
Your Honor, that's a very difficult question. Hasn't been to the board yet. But in terms of the privacy of that hypothetical, that's about as private as it can get. I agree. I guess the question would be whether or not the abuse of that child was a student who attended the same school where he or she taught.
So the standard is not any crime against children, because all teachers have a right, have an obligation to protect children. That's not the standard you're suggesting.
Well, no, we are, Your Honor. We're submitting to you that
Any crime against children,
Any-
regardless of its relationship to the specific responsibilities and job, would be the grounds for a teacher losing his pension.
yes, that would be the public policy
All right,
consideration here.
So there are thousands, literally thousands, of state employees, maybe local employees as well, but state employees who take an oath of office to abide by the rules and regulations of the Commonwealth, uphold the Constitution. Does that all of a sudden make them, put them in a position where a violation of any of those, any aspects of that oath now means that they have violated their responsibilities such that they lose their pension?
No, I don't think so, Your Honor. I think that would be an overbroad application of the statute. And as you've discussed in Bolger and Woodward, the statute needs to be constructed narrowly because it is a penal statute. But what we'd submit to you is you could employ, look at both parts of the test. Is there a direct factual link? If there's not a direct factual link between the crime and the member's position, then look to that particular type of public employee. So you may get a different result if you're comparing a snowplow operator or a DPW director to a teacher or a court clerk like Bolger or a police officer like Durkin. There may be different results depending on the type.
Direct factual link. So let's assume a teacher is retired. Been retired for a number of years. He then gets sort of caught up in an investigation like this one, and he is convicted of possessing child pornography. No evidence that he did so while he was a teacher, or certainly no evidence that any of the pornography had anything to do with any of his students. Same thing? Or is it just the fact that he did this while he was a teacher?
Yes, Sean, it's an interesting question, and I guess Bonomo may call that into question in the sense that Mr. Bonomo lost his pension, a pension he accrued based upon a period of time he was an alderman, and he commits a separate crime after he's arguably retired, wholly unrelated to his position as an alderman. So I'm not sure how our board would come down on an issue like that, but it's a challenging issue.
What would you say about the teacher who smokes marijuana with students? Would that be sufficient to lose their pension?
I think so, Your Honor. I think in that instance, you would get to the Gaffney analysis where there's a direct link. If they were students that he or she taught or students in his school, you know, a lot of times we're presented with cases involving a teacher who may sexually assault a student, and that particular student is not part of the district where he or she taught. But fortunately, most of those cases, the member has not had enough service where they've been vested, so they typically will just say to us, give me a return of my contributions, I'll forfeit the interest. So the board hasn't had to deal with that specific issue.
So, assuming we agree with you, what's the general message to teachers of Massachusetts?
The general message is, if it involves children,
Don't do it.
don't do it. Whether it's on duty, off duty like Mr. Bulger, off duty like Mr. Durkin, there's a link there. It goes to the heart of their role as a public employee. It goes to their core responsibilities, protect children. And the court, you know, talked about this heightened standard in the Brum decision, which, Your Honor, you were involved in, as well as Dupre and Perryman. And, you know, the board's aware of the overbroad application of the statute, but here we submit to you that it's narrow. If it involves children, you're going to lose your pension.
You know, I'm just curious, what if you had the same facts except the person was the school janitor, not a teacher? Same result?
I don't think it would be the same result, and the reason being, unlike the teacher who, under the statute, Chapter 71, Section 30, and the DESE regs, and the case law, who carves out an exception for teachers as a certain type of a public employee, if the same doesn't exist for a janitor, some sort of statutory guidance or case law saying a school janitor holds he or she should...
Different result.
Different result, yes.
How about a school administrator?
A school administrator, yes, I would say, same result as in Garney, that there would be a forfeiture.
But you wouldn't have the 7130, would you?
No, but I think in that particular instance, you'd still have DESE's guidelines, you'd still have the case law that talks about the duty of an educator to protect children. So presumably, even if the administrator didn't work directly with teachers, they're even more responsible for the care and protection of the children, which is actually discussed in the Brum case.
Now, in this case, what if the teacher's spouse was convicted of the child pornography, and the teacher knew that the spouse had the computer and was downloading all this material, and didn't do anything about it? Is that a problem for the teacher?
Yeah, would you mind repeating just the facts about...
Yeah, the teacher's spouse is,
yeah.
Maybe instead of a spouse, the teacher's roommate is downloading pornography on the computer. The roommate is convicted, and the teacher knows that it was there, knew that the person was doing it. Teacher didn't, look at the computer himself or look at the material himself, but didn't report it. Does the teacher lose his pension?
In that particular instance, I don't think so, Your Honor. And you may be, I assume you're trying to get to the issue of a teacher's designation as a mandated reporter under the statute. The mandated reporter statute says that a teacher is obligated to report in his or her professional capacity We cite to the mandated reporter statute in our brief simply as one additional factor along with the DESE regs in Chapter 71, Section 30, that goes to this notion of special public trust. So we don't think, and to answer your question, the mandated reporter statute would apply in that particular instance.
With regard to the direct link analysis, do we have any cases apart from Bolger in which there was not some connection to the employment? There's some misuse of property, some conduct on the job, something? I mean, does Bolger stand alone as sort of as sort of a variation on the direct link requirement?
Well, we're submitting to you that Bolger is not necessarily the direct link analysis. Bolger is sort of the higher standard where, when you looked at the record, there was nothing that Mr. Bolger did in the course of his official duties.
Right, and that's my question. Is that the only case in which we have not applied the direct link analysis?
As far as I can think of, yes, Your Honor.
Well, thank you very much, sir.
Thank you.
May it please the court, good morning. I am Michael Donahue, I'm representing Ronald Garney. At the outset, I would note that Mr. Garney is pled guilty to reprehensible crimes. There's no question about it. They're horrific crimes, and he was punished. He was sentenced to 2.5 years at state prison and 10 years probation, I believe the record will reflect. But having said that, I think what the MTRB is doing here is essentially reading out the direct link analysis that the court had set forth in Bolger and reading a broader, higher standard doctrine into a rule that can never be analyzed specifically if teachers and under Section 21 of 119, firefighters, police officers, and a whole variety of professions have as mandated reporters. How do you apply higher standards to those professions? Teachers don't stand alone in this context, and that's why we urge the court to adhere to what it has maintained since Bolger as a direct link analysis to look at whether there is a real factual connection.
Could I ask you a question in that regard? I don't know how far that analysis would go or how narrow it should be. What were the age of the students of your client?
He taught ninth grade.
Ninth grade?
Ninth grade, yeah.
Okay. So you would, I guess, under your approach that you want us to take, you would say that if he were having a sexual relationship in the privacy of his own home with a non-actual student that in his school, but from the next town, and he got caught and was pled guilty, that's okay, though. He shouldn't lose a pension.
Well, I think it's a tougher question than the one that's presented in this case.
I'm just trying to find the outer limits.
If this is a real child. It's a student.
It's a real child, just like these other students.
He's committed an act in his own home.
Yes.
I think that's very different than the internet pornography type of.
Well, then let me ask you about why it's different. So there's no question that these are actual children on this internet.
Yep, I believe so.
Right. And so, in fact, they found some of them, right? 21 of them were able to be identified. So it's because they're actual children is it because they're actual children who you don't know live in the Massachusetts who are in the ninth grade, or it's because there's maybe they live in Alaska and we don't really have to worry about them?
Well, no, I think we have to worry about any of those things.
I understand, but I mean for the purposes of defining the outer limits of the principle.
Outer limits may
the
well
narrow.
be raised in the Maynard and Tyler case, where you have a firefighter who was also a mandated reporter, who has been found to have engaged in sexual misconduct with a niece and the daughters of some of his colleagues in the fire department. There was no forfeiture in that case. despite the fact that he was a mandated reporter, despite the fact that these were physical crimes committed, not related specifically to his job, but as I
was
think
the point, right.
the appeals court had found that, that they were the children of colleagues.
Correct.
And yet there was no forfeiture because there was no direct link
But
found.
that is different. I mean, I agree that both teachers and the firefighters are mandated reporters, but the duties of the firefighter per se are not direct. I mean, they need to protect the community by fighting fires, but it isn't focused on children. I mean, so
That's correct,
there's quite a difference between a teacher and a firefighter in that regard, I think.
There is, but I think that also speaks to the limitations on how you can use the mandated reporter doctrine.
But I
in
don't
this.
think, I didn't hear the board really relying very much on the mandated report.
Well, they do in their brief, I believe, Your Honor, and they talk about the highest standard. And what I believe the appeals court had said in the Tyler case was, if that standard is applied and mandated reporters are required to exercise responsibilities that are just because they are named in the statute, that would engulf virtually all public employees who are within the statute or within the ambit of the statute. We think that there's a limitation in how mandated reporters are required to behave.
If one of the child subjects in the pornography in this case had been a student of Mr. Garney's, would that have made a difference?
Yes. Yes, because that would have been a direct link, a work connection.
But assume in Justice Spina's hypothetical, not that he made the pornography, but that child, somebody else did it, he purchased it, which is what we have here. He purchased it online, had no connection to the actual photography or whatever that made the,
Like if
but
one of the
purchased it.
21 turned out to be
Yeah,
one of those
if one of
students.
what happened to turn out to be one of the Amherst Public School students, would that?
Probably. I think that would probably be a link, there's a connection. Just factually, and to focus on the facts here, is that the police reports and the colloquy would indicate that it's not an abstract crime, because when you have crimes against children, it's never really abstract. But this is pornography generated in the Netherlands,
I
in
understand
Germany,
that.
in England, in all over the country.
But it's
Not a
still
good thing.
child pornography, right? It's not
Not
a
a good thing, it's a crime. He was punished for it, but the Human Resource Director testified in the record on the forfeiture hearing, is that there was never any question of Mr. Garney doing anything improper on the job.
Mr. Donahue, let me just follow up a little bit more with, so you would agree if the child was, if there was a child in Mr. Garney's class, there's a direct link.
Correct.
If the child was a student in the school, would you agree there was a direct link?
Yes.
How about a neighboring school?
If it was within the
Within the
community in
school
which
district.
within the community he taught, I would say there's a direct link. But there's nothing in this case that indicates that he did anything which impacted this community. Quite to the contrary, the police reports indicate, and the testimony and the forfeiture proceeding indicates that there was nothing. It was all in the privacy of his home. I'm sorry, Justice.
And going back to the mandated reporter, I mean, the examples that were given by Justice Duffley and by the Chief Justice would all be identifiable persons who he could report. Would that make it a difference?
I think so.
So if he had somebody who he would identify, then he would have an obligation to report that this child is being used for child pornography.
Yes. The question whether or not he would be obligated to report it, I think, raises other problems such as Article 12 and Fifth Amendment issues. But if that does provide, we think, the direct link, if it's a student in the school, student in the community, and he's shown to have engaged in that behavior, which impacts on the community itself, that's an affirmative act, which I think does tend to provide the direct link. But to go back to, I'm sorry, Justice.
Well, I just wanted to ask you this. If you're a citizen of Amherst, whose children have been through the Amherst Public Schools, and indeed, maybe even took science in 9th grade from Mr. Garney, and does the fact, I'm going to assume that the citizens of Amherst might be sort of horrified about this teacher having it, getting convicted, and the idea of being able to retain the pension may be some trouble. I'm just wondering in terms of public policy, public perception, which I think is part of the boards. This is a higher calling. These are role models for their students, and here is this teacher engaged in activity that is criminal and directly abusive of children.
I think the community would undoubtedly be displeased. But I don't think, in fairness to Mr. Garney, that's not the point. And that certainly wasn't the point in the Bulger direct link analysis. It wasn't the point in the Scully case, which I believe involved a librarian who met a student, or met a child, a 15-year-old boy, at the library, took him to his home, showed him pornography on his home computer. And he pled guilty for slightly different offenses, but there was no direct link found in that case, and Mr. Scully still receives his pension. The direct link analysis is not without its difficulties, but I think it's the best we have in looking at this, rather than to read into some higher standard, higher duty, higher calling, just because you're a teacher. It's a wonderful profession with all sorts of obligations that teachers have on the job. But I'm not sure it follows them to vacation in Canada or out of state. I'm not sure that it is something that follows them on weekends when they're totally unrelated to their work. If it's related to their work and it involves a public pension, then there is a direct link.
So how do we distinguish this case from Bulger? He goes before a federal grand jury with regard to a federal criminal investigation and commits perjury.
Correct.
And we say you lose your pension because oath-taking is so central to the job of a clerk. Here we have a teacher for whom the protection of children is central to their work, and he's involved in activity which, by its nature, involves the exploitation of children. How do we distinguish?
Well, I think the Bulger direct link is outlined very carefully in the opinion. He violated court rules. He violated the canons of ethics. He didn't merely do bad things in committing perjury before the federal court. He violated a lot of rules which are integral to his job as a clerk of court. I don't think that's the case with Garney. However horrific the crimes are, we don't see that there's a direct link between doing something outside of your home, in your home, outside of the work, unrelated to the work from a factual perspective. It's not good, but there's no direct link to his job performance. And I think you have to have some kind of standard that you're going to apply, which will be useful in the next case. And when you have, I believe, Scully and Gaffney and Maher and the Herrick case, you all have work connections or work-related connections. Excuse me.
What about a prosecutor who is convicted of a crime? Is that more akin to the Bulger situation? Any crime. I'm talking about a crime, let's just make, for the sake of argument, a crime of violence. Convicted of a crime of violence, loses his job as a prosecutor, but does he also lose his pension?
Perhaps. I mean, I think that it depends upon whether or not there was a direct link to his job as a prosecutor. And you look at the Durkin case, which involved the police officer using the service revolver to shoot a colleague while he was drunk on the way home. That's, I think, closer than what we have with Garney. There's nothing factually, and I think in looking at Garney, and looking at the facts in Garney, there's so limited a work-related connection that it's really a stretch to find that what he did, thank you, that what he did was linked to his job performance. And if it's read to constitute a direct link to his job performance, I think we're opening the door to any number of other public officials being subjected to the same kind of 15-4 analysis to lose their pension. It's not entirely relevant to this issue, but I mean, the question of the conviction of a criminal offense is, I think, to be read independently of whether or not somebody's going to be eligible for a pension. No question that Garney was, I'm sorry. That's it.
Thank you.
Thank you, Your Honor.
All right, we'll take our morning recess.